the training just so that gets captured in the recording. Okay, now everyone knows we're being recorded and we're here on this wonderful day to talk about victims' rights and legal standing, understanding Act 77 of 2022. As I just mentioned, we are recording this. It's going to be recorded so that those of you who could not join us in person for this via a live session today, folks will still have access to it. So if you have colleagues who weren't able to join, please know that there will be access to this. We also are going to be very interactive today, even though we have a large group on the line. There will be chat moments, there will be polls, and the more you participate, the more we can make sure that this training responds to what you are seeing on the ground. So we're going to start by using the chat right now and having folks practice just a little bit. And so what I'd love to do, we already see one person saying yesterday was great. What we would love for folks to do is put in the chat just a little introduction of yourself and tell us, were you online yesterday? Or is today your first day joining? They're different trainings, but they can build on each other a little bit. So introduce yourself in chat and let us know, were you with us yesterday for that training? We'll just take a moment. Wonderful. We have folks who were here yesterday. No pressure. We're going to ask you to share things as we go along, maybe. You have a different level of knowledge. Wonderful. Wonderful. Some new folks. And that's fantastic. They are different trainings. So let me share just a little bit with you about NCVLI and also the agenda. So as we move into today, I want you to know a little bit about the agenda because it is different than yesterday. Yesterday was really geared to ensuring that advocates in the community understood some fundamentals and started giving hints about legal vocabulary. Today, we're shifting gears and going legal vocabulary heavier, not heaviest. That's going to be for the lawyers tomorrow. This is a multidisciplinary day in many ways. So we're going to talk about Pennsylvania's victims' rights laws. We're going to talk about standing after Act 77. We're going to start to then shift gears into motion practice. That's what lawyers need to do to activate the rights in court. And then we're going to give examples of successful victims' rights litigation from across the country so that all of you there can start to vision forward. How can we activate the rights differently than we have in the past by leveraging this new explicit law around standing? So that's the flow for today. Again, there'll be some repeat or overlap from yesterday. Those of you who were on yesterday, just count that as deepening your knowledge and hearing it through slightly different vocabulary. Those of you who weren't on yesterday, don't worry, you're fine. We're going to elevate everyone's boat today. So you're really going to learn some motion practice today. So who are you going to learn from? Who are we? As I noted, my name is Meg Garvin, director here at the National Crime Victim Law Institute, and she, her are my pronouns. NCVLI, which is short for National Crime Victim Law Institute, we work nationally. We work nationally to promote comprehensive and enforceable legal rights and access to knowledgeable attorneys. Comprehensive rights, as I noted yesterday, for those of you who are online, that's making sure that there are rights that touch all areas of a survivor's interaction with the system. So from the right to be present, to be heard, to restitution, that's comprehensive. We work nationally to make sure the laws are really strong so that survivors can have rights across the spectrum. But then those rights aren't very meaningful if they aren't enforceable. And so we work to make sure that the law is clear, either in legislation or through litigation, that the survivor can activate those rights themselves in court. That's enforcement. And you're going to hear a whole lot more about what that looks like in motion practice today. And we work to do everything in a crime victim-centered approach through our education, our legal advocacy, and our resource sharing. Who is we? I've said we a whole bunch of times. I've already introduced myself. NCVLI has a staff of 14 lawyers and advocates who work to advance victims' rights. You have the pleasure, and it is a pleasure, to have two of my colleagues do a lot of the training yesterday and today. And so I'm going to turn it over to Rebecca Khalil and Terry Campos to introduce themselves and then take it away.
Thanks, Meg. So I'm going to jump in first with introducing myself, and then I'll turn it over to Becca, who will be co-presenting today. My name's Terry Campos, and I am a legal team member here at NCVLI, as Meg said. I've been with NCVLI almost 15 years, And motion practice, this is really the meat of what we do. I'm really excited for today. And Becca and I swapped roles a little bit from yesterday. So if you were here yesterday, you're going to hear some of the same stuff by a different voice. So from me, and then you'll hear from Becca talking about some of the things that I discussed. So you can get kind of a different perspective, hopefully. But with that, we will be taking breaks. So if you see that 2.5 hours and you're thinking, oh no, that's a long time to be sitting here, we're going to give you a couple breaks. So don't worry about that. And please feel free to ask questions, and we will try to follow the chat as much as possible. I know with a large number, sometimes it gets going a little fast, but with 2 of us, we try to keep our eyes on the chat and then fill in the questions as much as we can. But if we miss them, we'll come back to them hopefully at the end. And with that, I'm going to turn it over to Becca to introduce herself.
Well, thank you, Terry. So this is review for all of you who were on the line yesterday, but I'm excited to meet some of you who are new to the training today who weren't with us yesterday. So my name is Becca Khalil, and I'm one of the other members of the legal team here at NCVLI. I've been at NCVLI for about 12 years and focusing on all aspects of victims' rights litigation. So as Terry mentioned, motion practice is sort of the bread and butter of seeking enforcement of victims' rights. So we are excited to talk about how that works, how it could look, how it might look over the course of the day today. So thanks.
Great. And so first we want to know who you are. I know we've got you coming up on the chat. And so please feel free to scroll back up and see who is on the line with you today. But what we want to do is narrow it down to categories, which we don't always like to put people in categories, but we're going to do that right now, just to kind of gauge who's here on the line. So our first poll, and it's going to come up in chat. And so be looking over in chat. If you can't see the poll, scroll up because you might have missed it. But this one is just, what would best describe your role? What your job? Are you a victims' rights attorney, a prosecutor? Do you work for another government agency? Are you a civil attorney, advocate? So let's just fill that in so we can see who is on the line. And I see the numbers are going up. I really love this, how it does it in real time here on Teams. It's kind of fun to see. And again, if you lose it, scroll up and you can see the poll is there. So awesome. So it looks like we've got mostly advocates, but we do have some prosecutors and some nonprofit attorneys and civil attorneys. Oh, and some victims' rights attorneys. Awesome. So feel free to jump in with any knowledge that you have. If you want to supplement what we're saying, or if there's like a little piece that you think is really interesting that we need to know, feel free to put that in chat because we would love to hear from you because you are the experts in this on day-to-day practice in your courts. And then so we're going to do one more poll before we begin, and that is related to the topic today, right? How are you feeling about independent victim participation in courts? How do you feel about that? Let's put the poll up in the chat. Are you excited? Are you like, yeah, it's about time? Are you curious? How is that going to work? I'm not sure. Are you concerned? Skeptical? And remember, this is anonymous, so we want your honest opinion here. We want to know how you're feeling about this. And hopefully, for those of you, I see that we've got some skeptical and concern coming up. Hopefully by the end of this training, those skepticism and the concern will be gone because you'll understand a little better what we mean by independent participation and how all the different actors in the system can coexist and actually improve justice for all, right? So it looks like this is great. So curious, majority of you are curious, which is great. I love that because curiosity breeds an interest in really learning. And so awesome. And we've got a couple who are really excited. We got some who are saying about time. And then we've got the concerned and skeptical. So this is great. I think we've got a nice range of folks on the line. And so we will hopefully all end up at that excited, right? At the end. So that's our goal. Okay. So at the end of this session, whoops. Yep, sorry. At the end of this session, our goal is that you will be able to explain the significance, right? Why are we here? We're here because of Act 77, and we want to know, what does that mean, right? So what does it mean for victims? And then we want you to understand the common challenges. Now that it's crystal clear that victims can come into court and assert and exercise their rights, we want you to understand that there may be some other challenges that might pop up and what those are and how to overcome them. And then also we want to identify the motions that you would use to seek assert and seek enforcement of Pennsylvania's victims' rights. So motion practice. We're going to talk about some examples that we've seen in other jurisdictions where victims have been in court. This is a common practice for them to come into court. So what are they doing? What does it look like? And how you can employ that here in Pennsylvania. And with that, so this is going to be a Mente poll. So this is something we want to look to chat. And Becca's going to put in chat a link. And you can go in. So when I say Pennsylvania victims' rights, what is the one right that comes to mind that Pennsylvania victims' rights possess? So go to that link that Becca posted in chat and then type in one right that victims in Pennsylvania have. And let's see what comes up. And there's a code 53241347. Enter that in and it will take you right to this poll. And then we'll see by word bubbles. So the more people who enter a right, the bigger that word bubble will get. And let's see what comes to mind for most folks. Ooh, here we go. Notification. Oh, it's getting bigger. Notification, privacy, restitution, protection, right to attend, impact statement, attend hearings, victim impact statement, attend hearings, right to a support person. That notification is definitely getting bigger. Oh, I see restitutions up there too in kind of the second size. And this is also a gauge to see how familiar you are with the rights, right? And I see Becky is putting in chat accompaniment. Yes. So yeah, notification is popping up, right? And clearly notification, having notice is important because it is the gateway right, right? Like you can't exercise all your other rights if you don't have notice of proceedings and what's happening in the case. So that's just a kind of a real fun way to see what it is that you think of when you think of victims' rights. And of course, you may know many other rights as well. But notification clearly was the one that came up most. So their next poll is going to be in chat as well. And the question here is, do you see these rights, the ones that we just saw popping up, right? The right to prior comment, to restitution. Do you see these rights regularly exercised in criminal cases? Do you see victims coming in and asserting their rights regularly in criminal court, in criminal cases? And it's in chat. And of course, this may be different, right? When we talk about exercising the rights independently versus through the prosecutor potentially, but just having those rights just generally involved in a case. And it looks like 58% of you are saying yes, that you see it regularly. And then about 40 saying no. So what we hope to do is that through trainings, through understanding what those rights can mean and what they can look like, that number will go up to 100%. That yes, they're regularly exercised in criminal cases, and they're asking for more rights, not just, you know, specific rights such as notice or restitution, but all the rights that are available to them. And so we're going to talk a little bit about what those rights are, and then we'll talk about how that they can go ahead and exercise those rights. So this is a kind of an elementary diagram, right? Hierarchy of law for those in the legal profession. It's an elementary concept, but it's here because we want to remind you, right, that you always want to go at victims' rights assertion and enforcement with the most strong right that you can, the law that's the biggest, most powerful. For example, you know, or using a metaphor, right? The courthouse doors have been closed to victims for a very long time. And when you're coming at that door to knock it open, you want to have the biggest battering ram you can, right? So when you're coming in that door and you're asking for the court to do something, you want to come at them with a constitutional right, if you can, right? A state constitutional right, the federal constitutional right. But then you don't want to forget about those other rights or other laws that are there that are also at your disposal. So statutes and rules. So you'd come out with a battering ram, but you know, you might also come at it with some sticks, and you might also come at trying to pick the lock, right? So Becca's laughing at my metaphors. I'm all about metaphors, but you want to use them all. That's the key. And you want to look all over in your statutory code. You want to make sure that you're using everything at your disposal because victims' rights are new, and you want to make sure that the courts understand that you have a right to be there, and this is why, and this is the authority for giving you those rights and affording those rights. And also those little things down there, the rules, and even below that, you want to be thinking about the court's inherent authority to manage a courtroom, right? You don't even need necessarily a statute to know that courts can do a lot in their courtroom that would make the experience better for victims. And so use that inherent authority to the victim's advantage. Be thinking broadly. Be thinking about all these laws, but also be thinking about what does the victim need and want, and how can we go about doing it. And just as a side note here, we all know that the state constitutional rights amendment, right, to the Constitution in Pennsylvania, that was struck down as unconstitutional. But we want to note, and it's very important, that it was struck down on a procedural reason, that it violated the single subject rule when it was passed, not because the rights within that amendment were bad or wrong. So keep going, keep putting forward, and look to Oregon, because we had the exact same situation in Oregon where the constitutional amendment was struck down based on the single subject rule, and then it was repassed. We now have very strong, good constitutional rights in the state constitution. So keep going, don't give up with that. But that said, we still do have rights in the Constitution, in Pennsylvania's Constitution. And these are rights that are more general and apply to everyone. And so here, just to note real quick, we're not going to go over these in details, but right, we have Article 1, subsection 1, inherent rights of mankind, including the right to protect one's reputation. You can think how that might help victims when you are when you're trying to accomplish a goal for that victim, what they want. Open courts, remedies by due course of law, section 11 under the Article 1. But what I really want to kind of pull your attention to, and it's something that NCVLI has been working nationally, the security from unreasonable searches and seizures, right? This is something, when we think of the Fourth Amendment, when we think of the fruits of the poisonous tree and how defendants have really used this right in criminal cases, and it's been very effective, the right doesn't just apply to defendants, right? It applies to everyone. And so as victims, when we have a subpoena and a court orders, say, a cell phone to be turned over or the computer, should we be using, hey, that's an unreasonable search and seizure? And note that there is case law that says a court order enforcing a subpoena is state action under the Fourth Amendment. So we want to remind you that there are other things that maybe you aren't thinking of that are outside the victim's rights heading that you can be using. And also don't forget about the United States Constitution. I know we have Dobbs that just, kind of made everybody think that privacy went away, but privacy did not go away from the federal Constitution. So we should still be thinking and asserting that as well. So constitutional rights, those are the big battering rams. And then, of course, we have your Crime Victims Act under the code. And victims of crime have the following rights. And before we go into what those rights are, I just want to talk briefly about the things that you want to be thinking about as you get ready to assert these rights. So when a victim comes to you or a person comes to you seeking to assert these rights, there's questions you need to ask to find out whether they're entitled to these rights, right? We need to know the definitions of victim. Who is a legal victim in Pennsylvania? Who is a direct victim in Pennsylvania? What is a crime that makes a person eligible for these rights? And then also personal injury crime, because in Pennsylvania, as we'll talk a little bit, there's a subset of rights that only apply to personal injury crimes. And then for victims of criminal acts committed by juveniles, we need to know if the victim has requested their rights, because that's also a requirement. So there's some of those things that we just need to know ahead of time, whether or not this individual who's before us would be able to assert these rights. But once we know we've answered all those questions, we've looked at the crime that was committed, and we know that it fits under the list of crimes that are specific in Pennsylvania to make them eligible as victims to assert their rights. Some jurisdictions, they don't have a list of crimes, right? It's just a general open-ended, if you're a victim of a crime within the state. Here in Pennsylvania, as you know, there's a list of specific crimes. So you want to make sure that you fall under that. And then the subset of personal injury crimes that are limited to certain rights. And we're going to talk about those in just a bit, what those are. But so once you know that you're a legal victim and you're entitled to rights, what are they? And we went over this yesterday, but we're going to go into it just a little bit more in detail because for motion practice, right, we want to understand it a little bit better than just a summary. So information concerning services, that's a pretty simple one, right? They have a right to information to know what services are available to them, but it's a key one, right? It's a key so that we have holistic services going to victims of crime, because we know it's not just the criminal case that they're going to need help with. Notice of significant justice system actions and proceedings. And that applies to all crimes in the list. It's not subject to personal injury crimes. It's applicable to all of them. And we know, as I said earlier, notice is a gateway right. So this is hugely important. And you all noted it in the Mente poll, right? There was the big right that everyone noticed, which means I hope that means that victims are getting notice of all these, right? That's one that's being afforded to victims, and it's well known. And so we don't have, that's great. And we have compliance, as we talked about yesterday. That's the system's complying with that right. The next one, not to be excluded unless the court determines that the victim's testimony would be materially altered if victim heard testimony at the proceeding. So there's a couple things to note about that, right? So first would be the standard, that the court determines that the victim's testimony would materially altered. From what we know, that's a really high standard. Right? That's not going to be easily satisfied. And we should hold the feet to the fire if someone tries to exclude the victim, because that is going to be difficult to show that the victim is going to materially alter their testimony. And the second thing to note in that is that they need to have heard testimony, right? Meaning that all other proceedings at the non-testifying stages, the victim should be able to be present without any issue. And then even if the court decides they're going to exclude the victim, they must make every effort to permit fullest attendance possible, right? So how can we do this without cutting into their right? And then prior comment, well, accompanied by a support person, and that's, I think that's a pretty self-explanatory right, so we won't go into that. Prior comment is limited to personal injury crimes, and that is only for if there's going to be a plea, diversion, disposition review hearing, and post-sentencing release. So any other hearing, such as sentencing, does not have that restriction on personal injury crime. So if you fall under that general category of crime, victims have a right to prior comment. In restitution, and the restitution is the right to be restored to the extent possible to the pre-crime economic status through the provision of restitution, compensation, and the expeditious return of property, which was seized as evidence. So here we have the fullest extent possible. And again, this right's a little bit amorphous because it throws in compensation and return of property. But basically the goal is right to return that victim to pre-crime status. And then we have notice of release, which we want to ensure because, right, victim safety, and also not to catch the victim off guard if suddenly they're out in public and there's the victim. So moving on from that, there's plenty of other statutes, not just limited to the Crime Victims' Rights Act. And also, this is an example too of where you want to use all your tools at your disposal. So we had the right to restitution in the General Act. Well, here we have a statute specific to restitution, and it's the mandatory restitution. And as you see, what's important here is regardless of the current financial resources of the defendant, court has to order restitution for the fullest compensation for the loss. So we're not taking into consideration whether defendant is indigent or not, and that's crucial because a lot of times I know prosecutors might be hesitant to ask for restitution, or the court might be hesitant to order if the defendant is indigent, but here that should not be an issue. And then moving on, victim impact statement. So we talked about prior comment. Now we're talking about before sentencing, being able to give a victim impact statement. Here, this statute is specific that a court cannot exclude a victim because they know they're going to be giving a victim impact statement. So just a little bit of more buffer and protection to keep the victim in the courtroom if that's where they want to be. And then moving on, there's just other statutes that you need to be aware of that can help protect victims and achieve their goals, right? Depending on what they want, looking to these rights to see if you can use them with the new standing to achieve those goals. So we have the Rights of Child Victims and Witnesses Act, and then Rights of Human Trafficking Victims. And we're not going to go into those. We just want you to know that they're there. So if you have a child victim or you have a human trafficking victim, you want to also be looking to these statutes. And then privileges. What I found very interesting in Pennsylvania is that you have very strong privileges. And so these can be some very important, significant tools for victims. We know, especially when we're talking about sexual assault, human trafficking, and domestic violence, privacy is crucial. Privacy is huge. And without protecting their privacy, they may not want to participate in the proceedings at all. And the more that we can show future victims that prior victims have had their privacy protected in these contexts, the better that we're going to have reporting of crime, right? We're going to have them participating in the system. So it benefits society in general as well. And so you have an absolute privilege to protect records and communications between sexual assault victims and their counselors, human trafficking caseworkers and victims, including their interpreters, which is great, and then also domestic violence counselors and advocates and victims. And I think here, one of the takeaways, right, is the chilling and making sure that when you're asserting this privilege, you're also not just relying on the privilege itself, but you're relying on maybe the constitutional right to privacy, and you're also relying on access to justice, to courts. So there's other things you can be throwing in to ensure that those victims' records are protected as well. And then finally getting to why we are here today, right? So subchapter C of Act 77 of 2022, legal standing. And now what's interesting, and many of you may know this already, but victims have had standing in Pennsylvania already. That this just made it explicit, right? If you look at the traditional standing analysis where victims have a right, they're going to have a remedy, which means they're going to have standing. And you can see that the case, there's a 2003 Pennsylvania Supreme Court case on the slide. And it just talks about the standing doctrine, right? Like if you've been aggrieved, you can go into court and ask for a remedy. And that's always been the case. But now what's really great is you have this wonderful provision now that says a victim or the Commonwealth upon request of the victim shall have legal standing to insert and enforce a right enumerated in this act or any other right afforded to the victim by law in the trial or appellate court or before the official body with jurisdiction over the victim's case. So I've highlighted here what you really want to focus on, right? So assert and enforce a right. So you have standing to come into court to assert it. And then if it's being violated, you can come in and seek enforcement of it. And then any other right afforded to the victim by law. So if you can, like we were talking about, you dig through your tools and you find that statute that provides a right or an interest to that victim, you can use this standing to go into court and assert that. So you don't have to worry about it being in the Crime Victim Act. You can come in and assert any other one. And then trial or appellate clarifies, hey, if I can come into trial court or if I go up on appeal, I've got standing to go up on appeal and seek enforcement of my right as well. So it's very, very clear. It's what really gives you teeth to go in and court, you don't have to worry about being sent out. Now, what the subchapter does not do, right? So this law for legal standing does not grant party status to a victim, and it does not grant this right to an individual who's been accused of a crime. So defendants can't use this as standing to raise any issue that they want. And it doesn't create a cause of action against the state. So in other words, meaning that the victim can't go in and sue for money because a right was violated. But it does give you standing to go into court and assert and enforce a right. And with that, we're going to talk, Becca's going to talk a little bit more about what's new, why this matters.
Thanks, Terry. So yeah, the whole issue of standing itself, as Terry already mentioned, is not new in Pennsylvania law. Standing has always existed in case law, but what is new is this explicit provision. And Here we go. I knew we had another graphic on this slide somewhere. So what this really brings to the table is that it makes standing a lot simpler to argue. You don't have to go track down all the standing case law. You don't have to apply the test from the case law in quite the same way. What you've got instead is you have that test right there in the statute. You have a victim who has a right, and now they can go into court. And that right doesn't have to be in the Crime Victims Act. It doesn't have to be in the Constitution. It can be anywhere in the law that the victim has that right. And now they can go into court either at the trial level or the appellate level to assert that right and seek enforcement of that right. So really it boils down the standing test to something much simpler, and it makes it easier to argue. Of course, standing still remains a really fact-specific inquiry, right? Because you have to have a victim. So you need to know, does the person I'm representing qualify as a victim for purposes of this right? Because not every right applies to every victim at every point in the case, right? So you have to still look at the definition of victim. How does my client, if I'm the victim's rights attorney representing the victim, how does my client satisfy the definition of victim? And then I need to be able to point to the right that's at stake or the rights that are at stake. That's really the hook for this new standing test, is you just have to be able to engage in that analysis. How do I meet the definition of victim, and what right is at stake? And then what do I want the court to do about it, right? So it makes the definition of victim still central. It makes the standing test still central. It just simplifies everything when you're asserting that right. And this doesn't mean that courts aren't still going to have like an intellectual barrier to the idea of standing for victims, because it has not been explicit before, and victims often did not go into court to assert and seek enforcement of their rights because it was just a little bit harder. But this really does boil it down to why it's easier, and it should allow you to get in the door to assert and seek enforcement of those rights in a much simpler way than you could do before the act passed. So the legal analysis is easier, even if it doesn't really necessarily change the fact that standing exists. It will make it easier to assert, which we love, which courts should love, because it will make their job easier as well. So here's a pop quiz for you. Who, based on the new law, has standing to assert and seek enforcement of victims' rights in court? Go ahead and use the chat and add that in. Who has standing under the new law? Victims, yes. Victims have standing. They could themselves go into court and assert and seek enforcement of their rights. Prosecutors have standing on request of the victim, absolutely. Upon request, a prosecutor could go into court and help a victim assert and seek enforcement of their rights. And then the victim's attorney, yes, absolutely. The victim's attorney can go on behalf of the victim and help them, because as we all know, most victims are not super comfortable playing the part of lawyer. And even if victims happen to also be lawyers, most lawyers are of the opinion that it is an exceptionally bad idea to represent yourself in most situations. They still might want their own attorney to go into court and assert and seek enforcement of those rights on their behalf. I'm seeing some other things that bring up the definition of victim, right? Who qualifies as a victim? It may not just be one person. In the case of child victims, it may include parents or guardians. In the case of deceased victims, it may include family members. So looking at who that definition of victim is, whoever falls within that definition of victim for the purpose of that right can go in and seek enforcement of that right, or their legal representative, or upon request, the prosecutor. I see a couple of things in the chat, and this came up yesterday as well. Advocate. Some folks are putting advocate in the chat. And that's one where we will caution you to be careful, right? Because going into court and asking judges for things is very much within the practice of law. So if you are using advocate in the non-legal sense, like a victim advocate, you want to be very careful not to be jumping over into unlawful practice of law by assisting victims by representing them in courts, because that's very much an attorney function. But if you're using advocate in the sense of like attorney advocate, absolutely. Attorneys can go into court on behalf of victims to assert and seek enforcement of those rights. So those are the three categories: victims by themselves, an attorney on behalf of the victim, or the Commonwealth, the prosecutor, upon request of the victim, can assist with that as well. And why do we get so excited about standing? Because we really do. We get very excited about standing. Standing is crucial because without standing, you've just got rights. I mean, you have rights in a book, you have rights on a piece of paper, you have rights in some statute filed somewhere in some judge's office. Without standing, you can't enforce them. You can't make sure that those rights happen and that they happen for you in your case. And if something goes off, you can't seek to make it right in the same way. So standing helps give meaning to those rights, and it helps flesh out the contours of what those rights look like. Because we've got rights in the books, right? We've got rights saying you have the ability to give a victim impact statement, for example. Well, what does that look like? What if I prefer to give my victim impact statement using a video? What if I need to record my victim impact statement and have someone play it in court for me? The rights themselves don't always go into explicit detail about how they might work in practice. Standing gives you the ability to make those arguments, to say my right does encompass the ability to record a video or play a recording. My right does encompass the ability to have someone else read my statement for me. And then someone on the other side of that argument might say, no, it does not. You only have the right to do this. The right should be read as limited. And then you go into court and you argue about it. And then you get decisions. And those judicial decisions help flesh out the contours and scope of that right so we can come to better understand what those rights mean. And it is through that process of litigation that the rights really start to take shape and take on a deeper meaning than they do when you just read them as if you're reading through the statute itself, because the statute itself doesn't really speak to practice in quite the same way that court decisions and opinions do, because they're based on real facts and real circumstances of cases. So a good sort of corollary to this is if you think about victims' rights being on the books, and you've had victims' rights on the books in Pennsylvania for a while, defendants' rights, the defendant's constitutional rights, have been on the books since shortly after the founding of the United States, and those rights also didn't always explain the contour of what they meant. So if a defendant had a right to a fair trial, we don't really know what a fair trial means. Is it a fair trial if my attorney fell asleep during part of the testimony? Is it a fair trial if somebody was using prejudicial language or assumptions about me in my criminal case? As criminal defendants had these rights, they didn't always know the scope of what those rights meant without an attorney there to argue and say, yes, a fair trial should mean this. And on the other side, someone else arguing, well, no, a fair trial doesn't mean that. A fair trial means something else. And as case law came to be developed, we start to understand and better understand some of the terms that seem more amorphous in the law have take on really concrete and specific meanings. Fair trial does mean this. Fair trial means you get that. Fair trial means your attorney ought to be conscious during the trial most of the time. So without having lawyers to argue these things, they don't go up through the court systems. Judges don't issue decisions, and you don't start to see the practical implications of how these rights can look in practice. And that's really one of the reasons why in the 1960s and 70s, 200 years or so after the rights were enshrined in the Constitution, we started to get all this case law explaining what these rights look like in practice. And that's because criminal defendants were given a constitutional right, were recognized to have a constitutional right to have an attorney in all their state felony cases. So all these attorneys came into the mix, arguing in all these scenarios how rights should look and how rights ought to work. And as that happened, the body of law increased and we came to a better understanding of what these rights look like. And the reason victim standing is so important is not just to be able to flesh out the contours of these rights, to be able to better understand what vague terms might mean in practice, but it's also important because victim standing and the ability to enforce those rights, to ensure they have meaning in your case, is really important for victim experience and empowerment in the criminal justice system. So when we're looking at the research tells us a few things, and that victim experience can be shaped by a number of different factors. And the first factor is the way in which they're treated by personnel within the system. So how you interact with prosecutors, with law enforcement, with courts, with clerks of courts. Anyone a victim comes into contact with as part of the system has a big impact on their experience in the justice system. The second main factor is the extent to which victims have choice and the ability to choose the extent of their participation in connection with criminal justice. That's a huge factor in victim satisfaction and victim experience in the system. And the third factor is the way that victims are treated during proceedings. Are they being treated with respect? Or are they being treated merely as pieces of evidence, right? There's a broad spectrum for victim treatment, and victim standing can really impact all of these because it gives concrete meaning to victim experience. It ensures that when victims have rights to something, like a right to notice, that right to notice happens. And it's not just a matter of being treated nicely by the people you interact with. It's a matter of having those rights afforded, because the research is also very clear that if you give victims rights on paper, if you give them this lovely list of rights and they think they have them, but then you don't actually follow through, that has a worse effect than if you'd never given them those rights to begin with. You're setting up false expectations of what they should expect, what they're entitled to, and you don't hold up your end of the bargain. And that has a really detrimental impact on survivors as well. So that's the sort of the dual reasons of shaping the rights, understanding the contours of rights with the purpose of ensuring that victims' experience in the system and victims' expectations of the system align with what we're promising them, and that we're promising them these fair and consistent proceedings, no matter which courtroom they go into, no matter which county they're part of, no matter how big or small their case is, that they're going to get this consistent treatment throughout the process.
So what's next? So we've heard about the rights, and what the new standing provision is, and we just heard about the why it's important. So now we're going to learn about the how, right? So how do we do this, right? And NCBLI's motto is that if the law doesn't say you can't do it, then you can until you're told that you can't. And Becca gave you some really good examples of what rights could potentially look like. And so keeping that in the back of your head, like we want to push the boundary, we want to push to see what these rights can actually look like. We're going to go through this motion practice, and we're going to be utilizing standing to file motions and participate in the case. And so now we're going to dive into the more practical side, and then we're going to take a break. So let's start out with a little checklist here, which is really helpful. And this is going to be for the victim's rights attorney perspective. And if you're a prosecutor, you don't obviously need to do some of these things. You don't need to enter a case, but you still have obligations, right, to ensure that victims' rights are afforded. But so we're going to kind of talk through this as a victim's rights attorney would be thinking about motion practice and how to represent a victim in a case. So victim standing in a criminal case is fact specific. So we need to know a lot of things. Is this right at issue in the case right now? So we need to know what stage the proceedings are in, right? If you're in pretrial, then defendants have a very different right, constitutional rights at play, than if you're in the trial stage. And this type of thing is going to be important to victims when we're asserting their rights. So we need to know what stage we're at. We need to know what rights are ripe and ready to be asserted. And we also need to know, hey, what are defendants' rights at this stage as well? So that's part of it, right? And then we need to know who the legal victim is under your statute. And also, it can be not even under the statute, right? It can be under just the Constitution. You're an individual who has the right to be protected from unreasonable searches and seizures. So, in that sense, you would be able to come into court. But you want to know, for the basic rights, who is the legal victim? And this can change, right? So you need to be looking at every time you're going to be filing a motion, you need to be thinking, is this person still a victim? Why? Because, for example, let's say a plea agreement is reached and the resulting charge that's going forward is a misdemeanor that erases the victim status of the victim. So you need to be checking and making sure that your victim is still a victim. And then also, depending on what right you're asserting, there may be a different definition that's at play. So the definition for a victim for restitution or to give a victim impact statement can be different. So you want to be looking to see, is this person a victim with legal standing to assert this right at this time? Who are the record holders? So especially for some, sexual assault, domestic violence, you want to know, are there any potential record holders that we need to be thinking about in protecting potential records? So have they gone to counseling? Have they mental health? Are there medical records that might be at play? Education records. Defendants are notorious for subpoenaing all kinds of records, things you would, cell phone records, Facebook posts, everything and anything. So thinking ahead of time, who potentially is out there that holds records that the defendant might want to be after. And so you're proactively getting ready, and you might be taking steps, right? You might be, and this jumps a little bit over to the communicate with others. You might be reaching out to those record holders and giving them notice saying, hey, if you receive a subpoena for the mental health records, do not turn them over to the defendant. Make sure you contact and give notice to me as the attorney so that we can work to fight that subpoena. So you need to be thinking ahead of time. And then identify what rights are at issue at that moment, right? Or what could become an issue down the road. Do you know that there's going to be restitution coming up down the road? Was there, significant economic loss? And then also you want to identify, has a rights violation already occurred? Where are we? Are we proactively? Are we going to be asserting rights? Are we going to be seeking enforcement of rights? So you need to know all of those. And plus more, but right, this is just kind of our checklist to kind of get in the game, what it is. Communicate with client. Now this again, and this, for advocates as well, expectations are crucial. As Becca was mentioning, if you provide the victim with a list of really wonderful rights, they're going to expect that those rights are going to be afforded in a certain way, right? And they may or they may not, but you want to manage those expectations so that they don't have this assumption that, oh, if I can have this right to prior comment to a plea, that means I can veto the plea, right? If I tell the prosecutor, I don't want that plea, they're going to listen to me. You need to manage expectations. You need to tell them what that right means, that it means they get to provide comment. That means they get to have their opinions and thoughts considered, but that doesn't mean they get to veto or control the case, so that they can exercise those rights and be satisfied with the result rather than feeling disappointed because it wasn't what they expected. So financial recovery options and prep. So if there is an economic loss, which we know in almost every single crime there is, you need to be talking to the victim at the very beginning about keeping track of records, keeping a financial log potentially of things that they realize they have lost, what they were worth, if they're going to be going to doctor's appointments, if they're getting insurance payouts. So having them from the very beginning, keeping track of the loss so that at the end, when you're seeking restitution, you don't all of a sudden have to scramble, right? And things are lost because you haven't been keeping track. And you want to be talking about the recovery options, right? And you also want to be talking about, so compensation, right? Like make sure they understand about victim compensation and insurance and stuff. But one thing also you want to do is manage expectations with that. So that's, they know that if they get a restitution order for $100,000, they may not see $100,000. That a restitution order is very different than collection, so that they understand how they might receive payment too. So all that information is something they have with them, knowledgeable, so they can exercise their options, because they may decide to waive certain rights if they are not what they want, right? If it's, hey, I don't want to receive $5 a month from the defendant for 20 years because that's just going to be something that reminds me of the crime and it's not worth it, so I don't want to seek restitution, that type of thing. So understanding what they want and what those rights mean. And what, again, going to what the rights the client wants to assert. Making sure that you're not over superimposing your own interests or desires on the victim, that you understand what they want, right? Privacy may be really significant for you, but the victim may be like, I don't care if they get my mental health records, it's only going to support my claim, and those aren't the types of things, I'm very open with that type of information. Let them have it. So making sure you know what rights the client wants to assert, and not kind of taking that parental role of trying to dictate for them. And then, does the client want to seek enforcement? If there's been a violation, does the client want to go for a remedy? because they have to understand too that that might slow down the process, right? Because there might be an appellate moment. It might, you might know, hey, this judge hates to be challenged, and boy, if we, put forth this trying to, overturn their decision, or if we challenge their decision, that's going to harm us later on when we want to do X, Y, and Z. So maybe we don't want to do that now, right? So just giving them information, making sure they understand what that means. Most of the time, I think a lot of clients, just the prolonging of the litigation is not something they want. I shouldn't say most of the time, but that is something that does come up, that timing is really important and crucial for victims. So keeping that in mind. And then communicating with others. Again, informing record holders, right? You might want to reach out. This is a strategy moment. You might decide that you're going to inform everyone, put them on notice that if they get subpoenas, you want notice so that you can challenge. Introduce yourself to the parties, defense and the prosecutor. This is crucial, right? You're part of the case, being collegial, being all that where you want to build a rapport and then have that relationship where there isn't animosity, to the best of the ability working with these individuals, so that they know you're there. They know to provide you with pleadings that they file, right? And they know to keep you on notice of things, but also you represent the victim now. There's an attorney-client relationship. Prosecutor and defense should not be communicating directly with the client, with the victim, without your permission. That's an ethics, professional responsibility, the rule. They need to be communicating through you to the victim unless you have given permission. And you can decide that. Prosecutors and victims attorneys often have that conversation with what type of information do you need to go through me, the attorney, what type of information can you directly communicate with the victim. And then formal notice with notice of appearance and assertion of rights. Okay, so we're going to talk a little bit more about that in a minute, but basically, you're the attorney on record. You want to come in and be on the record. You want to know when there's pleadings, when defense files a motion to search the victim's home, during discovery. You want to have notice of that right away. Any of these types of pleadings and actions that go on in a case, you want notice. And so having that formal notice and notice of appearance with the court is going to allow you, hopefully, to receive those notices. And if you don't, then you might be going to the enforcement stage, right? You might be reaching out and having another little bit of litigation where you say, hey, I'm on record, I get pleadings, so make sure that I'm getting notice. In assertion of rights, that's where you have a strategy moment as well. You may assert all the victim's rights at once, or you may have spoken with your client and you know that there's only going to be certain rights that they're going to assert. Or you may have a limited representation agreement with them and you're only going to represent them on, say, restitution. So you would be filing a notice of appearance and asserting the right to restitution. It really just depends on how, your involvement in the case, what the victim wants, and also strategy. Like I said, do you want to preemptively assert all their rights, or do you want to wait and assert them as they come up or become at issue? Generally, I think it would probably be one of our recommendations that you assert all the rights, but there could be very good reasons why you would not want to do that. And obviously that's up to the attorney to know strategically which is the best to go. But this is a kind of a general checklist that you can follow that would get, once you have standing and you're in there, and this is kind of the practice that we would kind of the steps that we would recommend that you would take or that you're thinking about. And there's obviously going to be variations on this and versions depending on what it is that, your goal is, the practice in your court, because we obviously don't know all the various different practices in Pennsylvania trial courts, but this is just a general overview to help you kind of get your head around what this new standing, explicit standing means in motion practice can be. So with that, we are going to have our first break. So we're going to take a 10-minute break. So we want to be back here at 10:05. Oh, sorry, you are 2 hours, 3 hours? This is when it's a struggle for me. Is it
5 past the hour?
Yes, 5 past the hour. Whatever hour you are at, it's 5 past the hour. We're going to take a break. So please, if you want to grab yourself a little bit of lunch or snack, do that now. And we'll be back to jump into the steps for seeking and asserting and seeking enforcement of rights. Okay, welcome back. So we're going to continue just a little bit more on motion practice and the steps to asserting and seeking enforcement of rights. So these are kind of the 3 steps that, or I guess, big categories that are involved in asserting and seeking enforcement of rights that you need to be thinking about. And we're going to stay again with the victim's rights attorney perspective. So this is really, I guess, another way of saying steps to giving meaning to the rights, right? Like how, like Becca was talking about with defendants' attorneys and how that really developed the body of law surrounding defendants' rights. This is what it's going to look like when victims start coming forward and developing what their rights mean. So I already talked a bit about notice of appearance, and I think key here is for notice of appearance, you want to really focus on the notice. It's not a motion. You're not asking the court to do anything. You're just making a general statement of appearance on behalf of the victim. Hey, we're here. We're notifying all the parties in the court that the victim is now represented by counsel. And it also really gives everyone a heads up. Hey, we're going to be an active participant here, right? We're here. We're kind of keeping track of what's going on, and we're going to be more involved than maybe, if we didn't have counsel present. And it seems, because we're talking about just a simple notice, that this should be really easy to do, to file and get in place. But Becca's going to talk a little bit later about an example of how maybe it's not super easy for filing and getting the notice. Real quick in the chat, for those of you who are attorneys and those of you who know, is it e-filing in trial courts here in Pennsylvania? I'm assuming it is, but I'm curious, because that would also maybe make a difference with how things are filed, how easily a notice of appearance for a victim can be filed. And while I'm waiting to see that, we'll move on. So assertion of rights. Yes. Okay. So it'll be interesting to see if any of you have had any issues with filing a notice of appearance, and if you have filed a notice of appearance. So I guess that's a good question right there. For those victims' rights attorneys and civil attorneys on the call, have any of you filed a notice of appearance in a criminal case for a victim? I'll wait to see if anybody's chiming in. But along with the notice of appearance, I also again talked about the assertion of rights. And again, that's going to be a strategic moment, because it's very common in most jurisdictions to just kind of do a general assertion of rights. We have here, not sure if our system will allow attorney other than defense or prosecutor to enter an appearance. And I see Becca smiling and nodding her head. Yep, we're gonna get to that a little bit. So general assertion of the rights, right? You just assert all of them. But there is some case law that a blanket notice of appearance might not be the best way to go, because we don't know about the rightness. The courts might find that it's, if the notice of appearance and the assertion of rights is challenged by defense or prosecution and it goes up, there might be some issue about, well, you've asserted all these rights and none of them are ripe. And so you might get an adverse ruling. So there's a little bit of strategy involved. If you're really unsure and you want to know, you can always reach out to NCBLI and we can see if we can have the ability to do some technical assistance for you on that issue. So after the notice of appearance and assertion of rights, you've put everybody on notice, you're there, you're in the game. Then it's going to be, right, the proactive or preemptive motion filing. If you want to assert rights, if you want to be thinking about, okay, we've talked to my client, we know we want to assert these rights, we're going to file these motions proactively, right? And we want to obviously make sure it's ripe, that we're doing it at the right time. But you can also be thinking, okay, it's not ripe, but I know that if I don't assert it now, it's going to be lost. For example, right, using a pseudonym at trial. You need to ask for that ahead of time, right? Because once it's in the record, you've got an issue of the victim's privacy already being violated and their identity exposed, and you'd have to go through a whole other steps to potentially get it redacted and sealed, but that name already might have come out in public in court, so you might not have even wanted people in the courtroom to hear. So proactively, that would be a motion that you might think of filing, right? Using a pseudonym during trial. And if the defendant is a family member, then potentially even asking for a pseudonym or going by initials for the defendant, because we all know in some small towns, if the defendant's name is there and everybody knows them and it's a crime against their child, everyone's going to know who that victim is. So thinking about that, another proactive or preemptive motion might be asking for courtroom accommodations. An example, defendant's family has been very hostile towards the victim and very threatening. You may ask the court ahead of time for certain accommodations. For example, you may say, hey, can you order the defendant's family to remain in the hall until the victim's seated and comfortable in the courtroom, and then when the family comes in, they have to sit in a different area of the courtroom so that there's some separation. Things like that could be proactive or preemptive that you need to be thinking of ahead of time, because if you don't assert them, that right could be lost or it could be violated. In this way, you avoid that. Some responsive pleading, so responding to other motions. In the chat, go ahead and what are some potential responsive pleadings that you may file as a victim's attorney? In response to certain motions by defense or prosecution. Motion to quash, yeah, right? We should all be jumping to that one. That one's a pretty straightforward. So subpoenas for records, right? If you have a subpoena for any record at all, you'd be responsive, you'd be wanting to file a motion to quash. What if, say, defense wants victim excluded from the courtroom and they file a motion to exclude? You would want to file a responsive motion arguing their right to not be excluded. What if defendant or the prosecutor, we had this in Illinois, a motion to introduce prior sexual conduct of the victim? You might be filing responsive pleading asserting rape shield. Motion of continuance if victim is unavailable on the date of sentencing. Great, yeah. So especially if defendant wants to set sentencing, you'd want to then file a responsive pleading. Motion for continuance could also be a preemptive, right? Because you know that it's going to be happening. And so you're asking ahead of time, hey, I don't want to lose this right to be heard at sentencing, so let's move it forward, or to be present. And then we're going to talk about appellate practice, but that's really more tomorrow. So just for today, you want to know that, we have our proactive, preemptive motions in the trial court, we have our responsive pleadings, and hopefully that's where it ends, right? The court gives us what we want. They say, yep, we agree with you. Your right means that you should be able to have the family of the victim sit away from you. Oh, yep, we're going to let you go by pseudonym because we want to protect your privacy. All those things. Responsive pleading, hopefully the motion to quash, it's successful and the records are denied the defendant, and you're done and you're happy, right? That's all you've needed. But if it doesn't go the victim's way, if you're unsuccessful, then you'd want to go in appeal, right? And I don't know your process for appealing, whether it's petition for review or if it's a writ, however that is, but you would go forward. And we know from our standing provision, you have standing in appellate court. So you have the ability to appeal these adverse decisions. So that's going to be a next step. And that's really tomorrow, more of a focus of tomorrow than today. But we just want you to be aware that that is key, because as we all know, once the appellate court speaks about what the right means, all the trial courts have to get in line, right? That's when they start listening. That's when they start getting in line and doing what it is that we think they should be doing and giving those rights meaning. Without the appellate practice, there really isn't going to have that real defined, this is what it means. Even if the trial courts are all following that practice ahead of time, there's no guarantee that they would continue doing it unless we have that really great case law, that really great, on the books, the appellate court said this is what it means, and therefore all trial courts have to follow that. So this is just really the very general basic steps to asserting and seeking enforcement. And we just wanted to kind of give you just a general overview so that you're aware of that. And now we're going to move on to the next topic that we were going to talk about today is some of those hurdles. So now that we know you have standing, you can come into court to do it, this is how you come into court and do it, what are some potential problems that might arise and you might be confronted with, and how to combat those? And I'm going to turn it over to Becca for that.
So this is my favorite slide in the entire slide deck because it's very punny. So a red herring that often comes up, get it? Red herring. We've got the herring. I actually don't know what a herring looks like, but we have a red fish that we're using as a stand-in for a herring. One of the arguments that's frequently made when a victim's attorney files a notice of appearance is that you're not a party to the case and therefore the court can't hear from you. So that statement is half true, right? You're not a party to the case. But it's that end bit that makes no sense. You don't have to be a party to have standing. And your explicit standing provisions and Act 77 make that very clear. A victim is not a party, and a victim has standing to assert and seek enforcement of their rights in court. Party status and standing are two totally distinguishable legal concepts that people often conflate. It happens a lot. So be prepared that even though you have an explicit standing statute, somebody will probably argue that despite that statute, you still don't have standing because you're not a party to a criminal case. It will happen. You will hear this argument. And the argument is it's just no good because the analysis for party status and standing are distinct. And there are plenty of good examples, and courts confuse this as well. So it can be helpful to remind courts, if you're facing a challenge like this, that victims are not the only non-parties to have had standing recognized in connection with criminal cases. This happens in other places that don't seem to cause the court this sort of intellectual angst that victim standing often does. So the media, for example, comes into cases asserting their constitutional rights to access, to be present, to information about cases. The media asserts their rights in criminal cases often. Nobody mistakes a newspaper or a television channel with a party. It isn't a question, I think, because they are so far removed from the facts of the underlying case that it doesn't cause this sort of intellectual hiccup that victim standing sometimes does. But courts recognize routinely that the media, a non-party, has standing to come into a criminal case and assert their rights in connection with that case, which is often to access certain materials. That's usually what the fight is about. But the case law is out there. They're recognized. It's not a problem. Party status is not necessary for standing. Another good example of where courts recognize standing without party status is in the case of privileges. When somebody has a privilege to assert, say there's a therapist or a doctor, and they have a privilege to assert, they can come into the case and assert that privilege without being a party, and courts don't really have a problem with that. So if somebody raises this red herring, they say you're not a party, you're like, absolutely correct, we're not a party, and then they say, but that means you don't have standing, you're like, that's not how standing works, right? So just be prepared to give some of those other examples, because in addition to having explicit standing, which is super helpful, it can also be helpful to remind the courts that this is not unusual. It doesn't happen all the time in criminal cases. Oftentimes, a criminal case is just going to be the state, the defendant, and maybe no one else really has that level of interest or rights involved, but sometimes it does. So being able to point to those privilege cases and being able to point to those media cases as other examples of non-party status in criminal proceedings can be really helpful to help overcome that particular hurdle. Another hurdle that comes up often is defendants' rights. And defendants themselves, right, often will say, you can't assert your right in this way because of my rights. But it can also come up from the court. Well, if we let you argue that, then what'll that do from defendants? It might come up from prosecutors. Well, I don't want to jeopardize my case because what about defendants' rights? And these are all really legitimate questions to be asking, right? Defendants have really established rights in connection with criminal proceedings. They've got state rights, they've got federal constitutional rights, they've got a whole body of case law fleshing out what these means, and participants should be thinking about defendants' rights. But where the limitation of that is that most of the time, victims' rights don't hurt or threaten defendants' rights. Primarily, victims' rights are rights that are asserted against the system. Many of them are procedural rights. They have rights to notice. A victim getting a right to notice doesn't harm or take away any of defendants' rights, right? Just said right like 7 times in a row. They don't infringe on defendants' rights. Rights aren't pie. So giving other people rights doesn't take rights away from somebody else, particularly when those rights are meant to ensure that process is followed properly. So notice is given. Victims are offered the opportunity to give prior comment. That doesn't hurt defendants' rights in connection with whatever those proceedings are. It's a whole separate right, independent of defendants' rights. And this is not to say that sometimes those rights could conflict, right? They could, they really could. Most of the time, defendants may have an interest that might be adversely affected by a victim's right. And I'll use the example of restitution. A victim has a right to restitution, and a defendant has a really strong interest a lot of the time in not wanting to pay a huge amount of restitution because it's a lot of money and it's a burden and it often takes a long time, and it's like it just follows them along until that obligation is satisfied. Defendants don't want to pay restitution. They have an interest in not paying restitution, but what they don't have is a right to not pay restitution. So sometimes defendants' interests may happen to not align with a victim's right. If the victim wants full restitution and a defendant really would prefer not to pay it, those two things don't conflict. Defendant has no right to butt up against the victim's rights, but even if they have an interest that might happen to not align with the victim's right. And so another example, sometimes they do align, right? Sometimes a victim might want to exercise their opportunity for prior comment on proposed plea agreements to urge a prosecutor to offer a more lenient plea for any number of reasons. That may happen to align with defendant's desire to get a more lenient plea. But it doesn't butt up against any right? Because defendants have no absolute right to get a certain plea agreement from or plea offer from the prosecutors, or to have a particular sentence imposed in a case, or to get a certain set of charges filed. These rights and interests kind of coincide and run sort of parallel to each other, but they don't often collide. Sometimes the rights could collide. And in those cases, that's what judges are for. The victim's rights attorney will argue on behalf of the victim that they have these rights, and for these reasons, they ought to prevail in this case based on this set of facts. Defense attorney is going to argue defendants have these rights, and they ought to prevail in this case based on this set of facts. And the court gets both and has to make its decision. And its decision will elevate all rights to the extent possible, which may mean that in this case, under this set of facts, victims' rights prevail and win out more than they might in another case, when defendant might have a stronger argument in favor of their rights in those instances where rights abut. But most of the time, those rights are not going to run up against each other, but you should be thinking in advance because the argument will often be made. And sometimes it'll be made with very little specificity. You might file a motion asserting a victim's rights. So for example, you might say, my victim has the right not to disclose their confidential communications with their sexual assault counselor, even though defendant has said they want it. And defendant might just say, I have a right to it. And you don't really know what that right is, but you should be thinking ahead to what they might argue, right? Are they going to be arguing that they have some kind of fair trial rights or confrontation rights? What rights might be asserted that could potentially conflict, so you can start thinking about and researching how to make those counter arguments. Sometimes there will not be another right that comes into stake. A victim, for example, might ask for restitution, and defendant will say, well, that restitution order would violate my rights. And there may never be an articulation of what those rights are. And that's a good moment to push for it, right? Defense attorneys are really good, and we encourage you in many ways to think like defense attorneys when thinking about what your client needs and what your client wants. Defense attorneys are very good at thinking about what their client needs and asking for it. So you want to be able to do that for victims, recognizing that sometimes those rights don't conflict, and you need to be able to back up your assertion of rights with being able to point to a particular right. Victims have concrete rights. They come into play in very concrete moments, and they can help victims in very concrete ways. So cultural hurdles when it comes to assertion of rights, these are just the moments of resistance that are going to come up when victims' rights attorneys first come into a courtroom. It's new, it's different, it's unusual for now in a criminal proceeding to have a victims' rights attorney there. You might be told, stay in your lane, you don't belong here. We hear from prosecutors and we hear from defense attorneys in this case. We don't need to hear from you. So be on your way, right? And it comes back to standing. What right is at issue? My victim has this right, and I have the ability to come in and ask for what I need. And the question that often comes up, at least in my mind, is what is the victim's lane anyway, right? It depends often on where you're looking at in history, where you're looking at in the culture of that particular courtroom, or in the culture of that particular county within the state. Are victims seen as just evidence? Are victims seen as a person harmed by the case? Are victims seen as active participants with these moments of choice throughout the process? And in different cases, at different moments, it can be all of them. It's not one or the other, but it isn't one to the exclusion of the other. A victim may be able to provide important evidence. A victim may be a person who was very concretely harmed by a case, and a victim has these moments of participation and rights throughout the case that matter. And when you're thinking of those lanes and what lanes you're in, think of the lanes that apply to your role as well. If, for example, you're a victim advocate in a prosecutor's office, your role is to provide support and information and options to survivors in connection with the justice system so they know about their rights, they can choose what they want to exercise. And sometimes your role is going to be able to be providing referrals to attorneys when a victim needs something that you can't offer. When a victim is asking for legal advice, or wants someone to file something, or wants someone to tell them what they should do in a particular case, those are all great moments for referrals to attorneys. And that referral moment is important, even if that referral to an attorney might make it a little harder for the prosecutor to do their job in the way that they want. Because victims' rights and prosecutors' interests don't always align. They aren't always on the same page. Prosecutors have the really wonderful ability to be able to assert rights and seek enforcement of rights on behalf of the victim if the victim comes to them and asks for that. And sometimes it will not be appropriate for the prosecutor to do that. The prosecutor might have to decline because there's a conflict, because prosecutors don't represent the victims. They represent the interest of the state, which may not be the same as the interest of a victim. But that doesn't mean a victim should be without remedy or without legal representation. There are other alternatives, even in those instances, and especially in those instances where the prosecutor is not in a position to be able to do that. And it could even be for things as, relatively minor as funding and caseload, right? A prosecutor simply might not be able to help a victim when a victim asks, even if they want to, and even if it all happens to align with their interests in the case as well. So making those referrals is really important. And having a victim's rights attorney doesn't always mean conflict, right? Sometimes it means conflict. Sometimes a victim is going to be wanting something completely different and asserting rights that are in opposition to everybody else in connection with the criminal proceeding. But having a victim's rights attorney means having someone else there who can explain the law, provide advice on the options, and help a victim do that insertion, which can take some of the pressure off of the other participants in the case. It takes the pressure off of the prosecutor to have to worry as much about some of these moments when a victim has another attorney that they can turn to. So being able to work with an attorney on compliance, on seeking enforcement, and getting those referrals outside of the prosecutorial world is very important. And having that independent person provides value to the victim in a way that's really different and unique. So we encourage you, even if you are in a system-based role, not to forget about those referrals because they're really, really helpful. So a few common legal hurdles. I'm going to bring all of these up at once because otherwise I lose my spot in the slide. There we go. So other common legal referrals beyond the red herring of party status, beyond the what about defendants' rights question, which you have to be thinking about as you go through. So the first one is mootness and ripeness. At what time do you assert rights? And you need to assert rights at the right time, right? You can't wait too long, or certain remedies may simply be out of reach. You can't do it too early because it's just not appropriate in the case because that's not when the right comes up. But you also want to be thinking ahead. So you don't want to wait and wait because you might have a great argument, right? You and the other participants in the case may have, for example, been referring to the victim by a pseudonym all throughout the pretrial pleadings. All the pleadings use a pseudonym in the place of the victim. All the parties have been routinely referring to the victim by pseudonym. The prosecutor's on board, your client's on board, the defense attorney's on board. Everything is working smoothly, and you all assume that this practice will continue throughout trial. Maybe the court's not on the same page as you. And several days before trial, they start referring to the victim and they bring up, well, we're going to start referring to the victim by their true name when they're on the stand. And you're like, wait, what? This was really important to my client that they only be identified by pseudonym, but now you're a few days before trial and you don't have time to brief it. And moving the trial is going to be very difficult and the court may not be receptive to it. But it's one of those things, if you think about it in advance, when you're thinking about use of pseudonyms and initials, you want to be thinking about it throughout the proceedings so that if the court has hesitation when it comes to trial, you have the opportunity months in advance to start briefing that and arguing about why it's important when the court has time to analyze it and issue an opinion. And if the opinion comes down in your favor, great. If the opinion doesn't, you can think about whether you need to seek appellate review. But you want to start all of these processes early enough that you have time to finish them by the time they need to be finished. So that's in an ideal world. We know that in the real world, you might get a call from a survivor and they have an issue and it's coming up right now and they've had no notice and they reached out to you and they just connected and you've got a week. So in reality, you might not have months and months in advance, but when it's possible to litigate some of these things in advance, you can head off some of these problems by thinking about the appropriate time to assert things. So the second common legal hurdle, the defendant's rights will be violated. Again, we already talked about that. That's just a false assumption about how the law works and how rights work. And courts are in the position to make that judgment. You're going to argue the victim's rights, defendant will argue their rights, and then the court does their job and sort of weighs those rights against each other and makes a determination based on the facts and the law of that particular case. What about double jeopardy? We didn't bring that up as a specific defendant's right. It's a real right, right? But that right is not super expansive. Double jeopardy protects against the trial being redone. So if that were to come up and double jeopardy were to be raised, that might foreclose one possible remedy a victim might seek. It is unusual for a victim to be seeking to redo an entire trial. That's not a common remedy that a victim seeks, but often defendants might bring this up at other points as well. So when you're asking a court, for example, to redo a sentencing hearing after a plea, you want to anticipate, will defendant be trying to argue that double jeopardy applies to the sentence as well as to the trial, and be anticipating that. It's been argued in various places around the country. In Oregon, for example, the court had to address that directly when a victim's right to be heard in connection with the sentencing was violated, and their remedy was to ask for a redo of that hearing so they could be heard. And the defendant raised double jeopardy concerns. And the court in Oregon heard all of the arguments, and those are one of those cases, right, where defendants asserting a right that directly butts up against what the victim wanted. They're saying, no, redoing that proceeding would violate my double jeopardy protections. And the court in that case found that it wasn't, that these were rights that kind of went by each other, that double jeopardy protected against the trial proceeding part, not against the sentencing hearing part. So being able to think ahead about what defendants' arguments might be and what defendants' rights might be at stake is really crucial, because sometimes these end up forming the crux of the argument over whether the victim can get the remedy that they're seeking in that particular case. No case law. That's another problem, right? But is it? I mean, not having case law means you have less to cite to, and it gives you the creativity and the scope to make the arguments that you need to make. So while it would be great and wonderful to have a case directly on point from an appellate judge within your appellate division, that isn't always going to happen. If it happens, it makes it easier. If it doesn't change your arguments and your advocacy on behalf of your client. You have the opportunity to create good law both for your client and for future victims, and help shape that and create the appellate case that you wish you had. Create the precedent at the trial level and these interactions with the court that you wish you had going in before whatever the issue arose. So it's a bit of a drawback, right? We'd all love to have the exact case on point every time we make a legal argument, but it's not really a hurdle. It's more of a challenge and an opportunity to shape the law moving forward, both for your client and for future victims. Non-party status, we already talked about, doesn't matter. That's distinct from standing. The real question always boils down to standing. Does this victim qualify as a victim who's entitled to assert these specific rights at this moment and be able to seek a remedy. That's really what the analysis comes down to. And simplifying that, if it comes to it in court and the fight ends up being about standing, being able to simplify that for the judge is really important. And then I want to touch on one more practical hurdle that isn't on the slide, but which was mentioned in the chat. Filing, right? You have to think about these practical considerations. In federal law, for example, right, there's explicit standing as well. And we still have attorneys, and there's been explicit standing for quite a while. This is not new. Many courts around the country, a victim can e-file in federal court and file their notice of appearance, receive notice electronically. Easy, right? It just works as it ought to, but that's not everywhere. Even though that explicit standing provision has been in place for a long time. Just recently this year, an attorney in California had to argue that not only did they have standing, when it is explicit in federal law, they had to do an entire briefing on standing still after years. And they had to argue that this standing needed to translate into practice of them being able to file documents using the e-filing system. And that ended up being one of the biggest hurdles. They simply didn't have a structure in place for a victim to be able to file a notice of appearance, to file pleadings, to receive electronic notice. And this can apply whether you have e-filing or you file in person, because showing up to the clerk's office and trying to file your notice of appearance when a clerk has never heard of a victim's rights attorney filing anything in a criminal case, you may not receive an electronic barrier to filing, you may receive a human barrier and reluctance to file. So anticipating some of those really crucial practical issues up front can mean the difference between knowing that it might be a struggle and being able to prepare for it the first time, or going into it and having sort of all of the after effects and what do we do when you hit the practical barriers of being able to file a notice of appearance in a jurisdiction that's never seen a victim's rights attorney before. All right, I'm going to turn it back to Terry. I got very excited about that. We will continue on a little bit.
Awesome. And before we move on to examples of what these rights can look like and motion practice can look like in other jurisdictions, we're going to just summarize what we've been discussing about what and the how. So when you're filing a motion for victims' rights, there's 3 components that you really want to make sure that you have in every motion. You want to assert standing, even though it's now explicit, but especially now because it's new, right? And there's going to be a lot of judges who are still ignorant about the fact that, oh, victims have standing, they can come in and do this. So you always want to assert standing. Plus, you always want to make clear this is a legal victim. This person is a legal victim who has standing to assert this right at this time. So all of those go into that standing analysis that you want to include so that you're not kicked out based on that, right? You want to have that in there. And then you want to argue based on the hierarchy of law. So like we talked about, you want to come in with that battering ram if you have it. And then you want to go for your hardest, biggest rights that you can put in there. And you also want to be inclusive, right? You want to make sure that you have alternatives in there too. And that's also, we're going to probably talk about this a little more tomorrow, but that would also protect you for if you want to go up on appeal, that you have all those other laws in legal bases in your argument that is preserved for appeal. So you want to just make sure you're kind of throwing everything at the court. Now, that said, you may have strategic reasons why you don't want to do that you want to rely on just one provision, and that's fine. But in general, the more you can give the court reason for finding for the victim, the better, because victims' rights are new, right? And so you want to make sure that you have all that law in there and you don't just cite the statute, but you provide some rationale, legal analysis, and reasoning. And then, unfortunately, you need to also then argue that the defendant does not have a countervailing right, right? Becca went into depth and detail about how these rights can coexist. You want to make sure the judge knows that, because we have seen so many times how courts are really hesitant, right? Like if you are a judge sitting in a criminal case, you know the girth of case law surrounding defendants' rights. You know all the judges that have been overruled, overturned, chastised, told they were wrong, and you don't want to be one of those judges. So you're going to be cautious if you're a judge. You're going to be thinking, oh, I don't want to get overturned, but what about defendants' rights? This is all, your criminal case is about the state and the defendant, so we need to protect the defendant. We need to ensure that we're not violating those rights and that my decision is upheld if it's challenged. So you need to be clear and you need to be very assertive in the fact that what you're asking for does not violate defendants' rights. So you want to make sure your motions, whether they're proactive, preemptive, or whether they're responsive, you have that information in there so that the judge, it makes it easy for the judge, right? The judge is able to come to that no-duh conclusion of, oh, of course, I'm going to afford this right. I'm going to do what this victim wants me to do. And of course, it's like in any motion, you want to be thinking about, should you have alternative arguments? Should you not? It's all strategic, and you just want to make sure that you cover all your bases and think about down the road that what you're asking for right now doesn't potentially affect rights down the road that you may or may not want to be asserting later on. And also having that conversation with your client about, if we do this, as if we ask the court for this and we don't get it, do you want to challenge it? Do you want to appeal? Do you want to potentially delay the trial or the sentencing, et cetera, depending on what you're asking for, and relying on what they want to do for that. And then another summary slide. Basically, it just comes down to, when you're asserting a victim's rights, it can take many forms, right? There's no actual, this is the way it works, because you could be asking for like the preemptive. You could be asking the court to do something, to start something, to do something differently, hey, like we were talking about the accommodations in the courtroom or the pseudonym. You're asking to do that, right? We need you to do this so that the victim's rights are afforded. And that's really, I think, when you really need to have that conversation with your client and be like, what do you need? What are your goals out of this proceeding? And then seeing if there's a way to wrap it in with a right and then ask for it. And of course, there's going to be times when you're going to have to tell your client, I'm sorry, that's not something that we can ask for. That's not, in the rights. But you really want to make sure that you're not just foreclosing that because it's never been done before. Because boy, do we hear that a lot. Well, that's not the way we do that here, or that's not the way it's done. And this is a great way to say, yeah, but it should be. You need to start doing this, because this is the best way for victims to feel like they're participating, like they're heard, that they are seeking justice as well. And so this is the way to do it. So I think it's really important for not foreclosing these new, as Becca said, be creative. It's an opportunity. There's no case law. And again, going back to NCBLI's motto, if the law doesn't say you can't do it, then you can do it until you're told you can't. So get out there, be creative, and do what you need to do for your client. See what it is that they need and see what you can do for them. Stop. That's pretty obvious, right? If the court is going to proceed to say, for example, the court is going to proceed to sentencing, but the victim's not there and they want to give a victim impact statement, that's the great way. That's the right time to be, stop, court, stop. You're going to violate victims' rights if you go forward. Stop what you're doing. Let's get the victim here. Let's do, set sentencing over. Rights are ephemeral. Victims' rights are ephemeral, right? They're rights of participation. So if proceedings go forward without the victim there, those rights could be lost. And so we want to make sure that we have that stop button ready to go to allow that victim the opportunity to exercise those rights. And that ties in, right, with the do-over. So if they are violated, if the court doesn't stop and goes forward, you want to be asking for a do-over. And again, this may be something new. This may be like, we don't redo sentencing. That doesn't, no, that's not possible. And there could all these legal hurdles could come up at this point, right? That's probably when you're going to see a lot of those legal hurdles. It's going to be, we can't redo sentencing because that will violate the defendant's, double jeopardy, bar against double jeopardy. And that's when you come in and say, no, that has to do with trial. As Becca said, it's not about sentencing. So, looking at what you're asking, what stage of proceedings you're at, what can you ask for, and going for it and asking for that do-over, because if you don't ask for it, you're not going to get it, right? but you have standing to ask for it now. So we want to be doing that. We want to be doing all of this: start, stop, and do over. We want to be in there, assertive, and making sure that we're doing everything we can on behalf of victims so that their rights are afforded. And with that little kind of rah, 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 we're going to send you off on another break so that you don't get too tired of sitting here and listening to us speak. So another 10 minutes. So this time it's at 1:55. We'll have you back. So we'll see you back here at 1:55. Okay. I think it's time. Waiting for Becca to show up to make sure I'm right on. Great. Okay, so now what we want to do is just take a minute here to, using the chat box, for those of you who are attorneys, list 2 motions that you have filed in criminal court on behalf of a victim or that you can foresee filing on behalf of a victim. Are there any here that just kind of struck a chord and you're like, oh, I want to try that? So go ahead and chat those. And for victim advocates, what are some motions you would like to see being filed on behalf of victims in criminal court? Like, what are you seeing that you would really like to see remedied by a motion? Go ahead and let's take a few minutes to put that into the chat box. And then we're going to go over quite a few. Presence in the courtroom. Reconsider sentence. And I'm wondering if, Justine, if that's because you're seeing victims being excluded a lot in Pennsylvania. Yes. Oh, interesting. Access. Oh, I'm reading that you no longer have access to the chat. I think that's not quite a motion. Well, interesting. So if you are seeing victims being excluded in the courtroom quite a bit, that is a great thing to be thinking about for litigation, right? To be having that motion prepared. So Patrice says, reading an impact statement on the record if the victim has already forwarded their statement to the pre-sentence investigator. So are you seeing that they're not allowed to make an oral impact statement if they've already have one? Awesome. Okay. Ooh, Deanna says Fourth Amendment enforcement to prohibit search of phones, etc. Yeah, that's what we are really focusing on that at NCDLI and hoping. There is a case now in Arizona where defendant sought the GPS tracking off the victim's truck. And in the trial court, it was argued motion to quash, and the victim and NCDLI went in as an amicus and argued that it was a violation of the Fourth Amendment. And it is now in front of the Arizona Supreme Court, and they are asking and looking at the Fourth Amendment for that. So it'll be exciting to see what happens with that one. Yes, I agree. It's pretty cool. What else? Let's think creatively. What else might we want to see? What are we seeing that victims are unhappy about that you might want to remedy through motion practice? And I know you advocate, I know you're hearing victims being unhappy about things. Or you're unhappy. Like, what are you seeing that you're just like, this shouldn't be happening? Timely notification, right? And timely is going to vary, right? It's going to vary depending on the victim. If the victim is elderly and doesn't have a car, they might need notification going back much longer, right? They might need a lot longer time to get there. Ooh, Rachel says expert witnesses for strangulation, no external marks. So you actually want to be like, hey, I want to have this, I want to allow expert witnesses to come in. And we have done that. We've seen that with rape myths, right? Asking for experts to be able to testify about the myths surrounding rape and how victims should act. Reconsider bail conditions. Yes, that's one we see a lot, actually, is a motion to reconsider bail release. Finding out what the victim needs to feel safe and then asking for it. Please sentence without victim notification. Oh yeah, those would be definitely things to be seeking enforcement of. No processing a case without making enough effort to contact victim, right? Are we getting the prior comment before going forward and making the decision not to prosecute? Yeah. Speedy trial. That's interesting. And Becca, I chime in if you know anything. I have not seen anything about speedy trial in your rights. However, that doesn't mean you can't somehow couch it in some other way. I could see potentially there could be ways or fact situations where you could bring it up and get to it, but I don't believe you have an actual speedy dispo right in your laws.
I'm actually really curious to see if folks use any of those constitutional provisions about I forget the exact language, but justice without delay,
Right,
because that's
right.
not victim specific, but that seems to be very universally applicable. So that might be a right that could be leveraged in that sort of argument going forward.
Yeah, these are great. These are all great ideas and options in that, just like what Becca and I were doing right now, just like thinking out loud and knowing what the victim wants and how can we get it, and then looking at what you have at your disposal. And that access to justice, that may be one, right? Speedy dispo, you may say, like, if it's not speedily resolved, there's no justice to be found, or it's going to chill reporting because victims aren't going to want to go through this really long delay. So there's potential ways of doing it, even without that explicit provision in your victims' rights statute. Great. Well, thank you for sharing those, because I think those are great. And now we're going to talk a little, I'm just going to give you a list of some motions that you might have thought about or you might not have thought about. Obviously, the motion to quash subpoena of a victim's private information. We've talked about that. That's a very common one. But think of it, go a little bit further. I mean, motion to quash a subpoena for, or motion to quash an order allowing defendant access to victim's home for pretrial discovery. So other pretrial discovery type of motions you might be wanting to file. Motion for accommodations. Again, this can be really broad, right? Because that not to exclude, you don't have to limit the not to exclude to just literally the court, you can't force victim out. Think about what might practically or effectually preclude a victim from being present. So for example, if you have a victim who needs to get up, for health reasons, their mobility, they need to get up and move and have circulation for like 10 minutes every hour. They can't sit longer than an hour. So you might say, under that right to be there in the court and not to exclude, the court has to make this accommodation for that victim. So pausing the trial or pausing whatever proceeding every 50 minutes, so the victim has 10 minutes to go and walk around, that would be something that you'd want to assert ahead of time. So being very, think very broadly about what those accommodations might mean. Motion to restitution, that's filing your own. So not necessarily just relying on the prosecutor to put forth a restitution amount. Calculate what it is that you need to make the victim whole, and then filing a memorandum, laying out the loss and why it should be ordered. Motion to identify the victim by pseudonym or initials. A motion to prevent pro se defendant from personally cross-examining the victim, right? That's huge, and we've had that several times come up. Motion to reconsider conditions of release, we were just talking about that. And that can be something that you base on victims' rights, or it could be something depending on your laws surrounding pretrial release. It may be something that could be sua sponte, raised by the court if you bring it to their attention that, that there's this condition that needs to be added. So look around and see what other tools you might have besides just the victim's rights. Motion seeking enforcement of the victim's rights to accompaniment of a support person. Well, what if that support person is actually a dog, right? Facility dogs are very common now in courtrooms in accompanying victims to the stand or in the courtroom, so that it eases their anxiety and allows them to be present. So that could be something that you ask for as well. Motion to return of property no longer needed as evidence. This has come up in cases where, clothing of the victim has been taken as evidence, but it's not even needed. It's just sitting there. Cars getting back, all these things where it seems like it shouldn't be an issue, that it should just be returned to the victim. We've seen very common where we've had to ask for it. But not only that, there's times where there has been, like, for example, a car. If for some reason the crime involved the car, and so the car was taken into evidence, like the victim having to pay to get the car out of the holding, which should not happen, right? The victim should not have to pay. So something like return of property may also require you to add in that without payment, right? You shouldn't have to pay for it. Motion seeking enforcement of victims' rights to notice of significant actions and proceedings. And hopefully you don't have to file that, but maybe you do. And maybe that is couched in the term of timely notice, right? Maybe you have to actually word it so that, because you know that this victim requires a certain amount of time to get everything in place to be able to act on that notice. So like I was saying, they're elderly, or maybe they are in a wheelchair, and so they need to arrange for transportation to and from the courthouse. So they need to have a certain amount of time ahead of time to be able to do that. So you would want to file a motion that lets the court and everybody know, hey, this is what notice has to look like in this case for it to be actually effective notice. Because we don't care that you're just sending out a piece of paper. That's not the point. Or that you're making the phone call and leaving a message. The point is to give actual notice, right? Give them information that they can act on, because that's the point of the right. So making sure that it is timely, it's accurate, and it's appropriate for that victim is necessary to effectuate that right. And with that, we're going to jump back to Becca.
So I'm going to take you through, and I'm going to start the process of taking you through some concrete examples of motions that have been filed to protect victims' rights. And these go beyond that list that we just covered to include some additional examples. Because one of the things that we found when working with attorneys is that oftentimes attorneys like to see samples. We like to know that someone else has done it. We like to see the structure of the arguments that have been made. Even if it is an argument that wasn't made in our specific jurisdiction, we can extrapolate from that to our own law to make appropriate arguments on behalf of clients. And victims' rights related motions are not something easily found by Google. Like I feel like you could probably find some really good sample motions, say to suppress evidence seized in violation of a warrant. If you're representing a defendant, you're going to be able to find plenty of examples. There's horn books, there's publications talking about these things. It's harder to find when it comes to victims' rights because the field is so new, and it doesn't mean they don't exist. NCBLI has worked on a lot of these cases with practitioners from around the country. One of the resources that we have, which we'll discuss in a little bit more detail later, offers access to a compilation of sample pleadings from different jurisdictions, arguing many of these things. So you can see what's been done, and you can see how it's been done, and adapt those to your own law if it happens to be from a jurisdiction that isn't yours. So we're going to dive into a couple of these examples and just sort of talk through how they look and sort of what could happen, what some of the possibilities are. So here's our first example. Is we've got a scenario where the charging instrument reveals the victim's identity. So the victim is identified by name in the indictment, and this is posing a problem for your client. And this could pose a problem for any number of reasons. Your client might fall within, say, the child victims' rights category or the human trafficking victims' rights category, where you've got some explicit protections against revealing victim identity. So this could be an oops, that it might not have necessarily meant to have been filed that way, but it was. Or your victim may simply have a privacy interest in making sure that their name, if they get Googled in the future, doesn't come up as it being associated with this criminal proceeding. This may not be the first thing they want someone to know about them if they do a Google search. This may not be something that they felt comfortable sharing with friends or family or colleagues, and would prefer to be able to share parts of their own story on their own timeline in a way that works for them and is within their control. Oftentimes when we think of this sort of scenario, we think of sexual assault. It is not limited to sexual assault. Many victims of many different offenses have concerns about their privacy and their name being out there in connection with the case. So thinking about pseudonyms and initials, even at the earliest moments, like all the way back in indictment, is really important. And often what is filed is, and we're using names of motion that we've seen in the past. And again, we encourage you to think like a defense attorney. Think about what your client needs and name the motion after that. So your client in this case might want to be identified by pseudonym or initials. So you file a motion to proceed by pseudonym or initials, right? You think of what the client needs and you name the motion that thing, and then you make the arguments drawing on the victim's rights laws. And another thing to think about when we're all the way back at this point of indictment, if things, or even after that, right? If you come into the case later and other pleadings have been filed that already use the victim's true name, you might need to pair that motion with a motion to redact or to place under seal and substitute some of those previous pleadings with ones that now use the pseudonym in place of the victim's name. So you can go back in time and fix some of those errors, which granted isn't always 100% fix, right? Things make it into the internet. It may be very hard to get some things taken down, but within the record itself, you can make motions to substitute those earlier filed documents with ones that replace the victim's name with the pseudonym or the initials that they prefer to use. And in our example, we use the motion to proceed by pseudonym rather than initials because for some victims that can be more protective. And when we're thinking about pseudonyms, we encourage you also to think about the level of privacy protection that a victim wants in connection with the case. A victim's identity may be more likely to be discerned if you're using gender-specific pronouns or gender-specific pseudonyms as opposed to a gender-neutral pseudonym or pronouns. So be thinking about what a client needs and wants when it comes even to things like pseudonyms, because Jane Doe may not be an appropriate pseudonym for your client, neither might John Doe. You may need to go to Jaden Doe or a different type of pseudonym in order to provide that comprehensive protection that they're looking for. So thinking about pseudonyms as well, you might want to think about victim privacy also in the context of non-disclosures, right? Sometimes people in the case, participants in the case, will need to have access to the victim's true name, even if all court proceedings and pleadings are filed using a pseudonym. So if that name needs to be disclosed to defense attorney, to defendant, whatever the case is, be thinking about protective orders that you can ask the court for to make sure that in addition to pleadings being accurate and using pseudonyms, that if somebody speaks to the media, for example, they're not going to then reveal the victim's true name to the media while using a pseudonym in the court, because that really undermines the use of that pseudonym in the first place. And so thinking comprehensively about those steps in advance can be really important. And also when it comes to redactions or substitutions, this goes beyond names and pseudonyms as well. What other information might also need to be protected from disclosure? And this can come up with things as simple as like the victim's address, right? It may be that the victim doesn't want their address or their block or their street identified for safety reasons. And that can be something you may ask for. It may be that a recitation of facts may not need to go in as much detail as to identify if this is a family-related crime, what exact relationship the victim had to the defendant in order to further protect that privacy. I'm seeing in the chat date of birth, right? Social security numbers. All of these things have come up that victims have had to seek redaction of because they can cause a lot of problems when they make it out into the public realm. And not just safety related problems, but it can lead to identity theft or fraud or another sort of cascade of problems for that survivor that they don't need to go through when you're thinking proactively about this. So absolutely. I'm going to move and bring the next example up and say we've got a defendant who was released on bail without notice to the victim, and the victim has some special concerns because of their history, their relationship with the defendant. You might file a motion for reconsideration of release, or a motion to add release conditions, or motion to modify the release conditions. You can use a number of different wordings, but you're thinking of what it is that your client needs, and you're going to be asking for it and using their rights as a way to do that, right? Because victims have this right to prior comment and comment when those things are changed in Pennsylvania. So victims have the knowledge and the experience to know what conditions will keep them safe and what they're going to need going forward. And without some of that input, the court or the prosecutor or the other players in the criminal justice process won't have that same knowledge and may not be ordering the release conditions that are really appropriate for that survivor. So keeping those in mind is really important. And then just making the arguments that need to happen in order to facilitate that right.
All right, so moving on to some other motions that might need to be filed. And we've talked a lot about motions to quash, right? And so that's for if the defendant or the state, right, because the state could also be seeking some information, issue a pretrial subpoena seeking the victim's hospital or counseling records, you're going to want to file a motion to quash. But in this, I also want you to be thinking, as Becca talked about, there may be these other motions or other asks that you may have. For example, if those records are already turned over, you may be wanting to file and ask for those to be returned, right? Or one thing that we see a lot is everybody seems to think, except for the victim and the victim's attorney, that in-camera review of the records solves the privacy issue. Like, well, oh, it's fine if we were just going to have them turned over and it will be just the judge. He'll just, he or she will review the records and that's great. No. In-camera review is still a violation of the victim's privacy. So if you know that records have been turned over, you can file a motion asking the court to not even look at the records until they've resolved the issue of whether or not they should be turned over. And then if they shouldn't be turned over, then they should go back to the record holder or destroyed. And so you want to have some potential in your motion to quash some other asks, other remedies or relief that you ask for. And then the next motion that may need to be filed is if the defense counsel or the state say they intend to introduce the victim's text messages showing evidence of past sexual history. So that's going to be a motion to exclude rape shield evidence. So what you're going to want to include in that motion, right, is you're going to want to look at the statute surrounding rape shield. And you're going to want to assert and argue that all the factors that defendant needs to show to include admit rape shield evidence they haven't been met. So you're making that legal argument around the statute. But what you don't want to forget is quite simply that big, important argument that the evidence of these text messages are not relevant to the fact of whether or not the defendant committed the crime. And I think we forget that often. It's kind of where the rape myths come in, right? Defendants will be seeking Facebook posts that say, we know they were sending photos of themselves the day after the rape and they were out partying. So we want to get access to their Facebook account so we can show that. It's irrelevant, right? Forget about that you can argue other things. It's just irrelevant. It should not be coming in. So when you're arguing rape shield, always throw in that it's not relevant to whether or not the defendant committed the crime at this point. And so that's just a really quick overview of those two types of motions that could be filed.
And here are some more examples. So in this scenario, a jury found the defendant guilty, and the judge said that they disagreed with the verdict, didn't believe the victim, and they commented that they would be getting a lenient sentence. What might be filed then? You might be looking at filing a motion to recuse the judge because they have already, before taking into consideration the victim's views, they've come to a different determination about the veracity of the victim than the jury did because they believed them and convicted defendant. The judge decided they just didn't like that determination, and so they were going to make their determination of sentencing before they heard from the victim, before they heard impact statements, before they reviewed any of the pre-sentence report materials. That may be an opportunity where your client wants that sentencing to go forward before someone else, before a different judge who is not already prejudged what the outcome ought to be before hearing from all the participants in the case. And I would encourage you also in situations to be thinking beyond the criminal courtroom. Sometimes it may be what the victim wants to do is file ethics complaints against a participant who is not upholding the standards of the profession in the way that they ought to be. And so it may not just be motions in a criminal case that you're looking at as options, but some of these other tools that can be used to make sure that players in the criminal justice system who have duties and responsibilities towards victims are acting in accordance with those obligations as well. So thinking broadly about potential remedies, what a victim wants at the end of the case, what they hope to achieve, and finding ways to accomplish that. Another example we've got, what if a victim has suffered some economic loss and it's really hard to calculate? Like they're waiting on documents, maybe they're waiting on medical records. The reality is that sometimes some of the information that a victim needs in order to make an effective motion for restitution may not be available on the schedule that the judge or the defense attorney or the prosecutor might prefer to hold the sentencing hearing. And so in some cases, in some jurisdictions, they could simply ask for a separate restitution hearing. In Pennsylvania, you might consider asking for a bifurcated sentencing hearing so that even if part of the sentence is determined at one point, The other part of the sentence involving restitution could be determined at a later date, or at the outset, you might ask for restitution for the whole sentencing hearing to be continued until a later date to allow you to gather that information that you need in order to make a comprehensive restitution request. So there are lots of ways to go about accomplishing some of these goals when a victim's rights are at issue and when they have potential to be violated. But I think working with the victim and having participants in the system work with the victim, especially at these moments where victim participation is more common. It tends to be more common at sentencing. It tends to be more common when restitution is involved and victim impact statements are involved. And that's a great moment to help facilitate that conversation between the victim advocate, between the prosecutor and the case, to make sure everybody's on the same page about what timelines look like and what might be reasonable and possible in a case going forward. So a victim may not even need to file a motion because it's being handled appropriately with their input at the outset. So just knowing that litigation is always an option, and not litigating and working collaboratively with the different players in the justice system can also be an option as well to achieve many of these same ends.
And with that, we're going to move on to giving you some real life examples of when victims have standing to assert and seek enforcement of their rights. What does it look like? What are some of these jurisdictions doing? So we're going to just show you what it could potentially look like. So right to protection. In a Utah trial court case, the court ordered defendant to remain in his home during the times that the minor victim walked to and from school, the school bus, as a release condition to prevent the minor victim from having to see the defendant who lived on the same street as the victim. So that was a release condition the victim asked for and was granted. And then in Arizona, this was a domestic violence case, and the victim they were in very rural areas, and the victim knew that if the defendant was out on release home confinement with the ankle bracelet, the monitoring device, that if it went off, if they left the home and the police were the only ones to get the signal that they left the home, the defendant would have time to get to her before the police. And so she asked the court to have that monitoring go directly to her so that she would have time to get to safety if the defendant violated the release conditions and left his home. So those are just two concrete examples of the right to protection in different jurisdictions.
And here's a restitution example from South Carolina. This is relatively recent. There was a victim, the victim and the victim's wife were both hit by a drunk driver, and the victim's wife was killed. The prosecutor in the case was not willing to seek significant restitution, and the victim's rights attorney was able to help with that. They filed a motion for restitution, and ultimately they entered into a settled agreement, like everybody agreed on the amount at the restitution hearing for almost $250,000. And this is a case where if the victim had not had their own attorney, that number might have been zero or very, very small, because other players in the system didn't happen to align with the position of the victim on restitution, even in a case where there was significant financial out-of-pocket loss on medical issues. And then the right to give a victim impact statement. I really like this example because it looks different from what often comes up, right? Oftentimes the question is, did the victim have the opportunity to be present? If they wanted to read it aloud or say it aloud in court, were they able to do that? Did they have notice of the proceeding? In this case out of New Jersey, what the victim really wanted to make sure happened was that the defendant was present. Because in that case, the defendant wanted to waive their right to be present at sentencing so they didn't have to listen to the victim. They didn't want to be there at all. They said, court, you can just go ahead and sentence me. I waive my right to be there. Just issue whatever you want. I'll be down the street, right? I don't want to be in the courtroom. And that was not okay for the victim. They felt like their opportunity to give an impact statement would only be meaningful if the defendant was there to hear how their actions impacted their lives. So that's what they filed. That's what they asked for, a motion requiring defendant to be present during sentencing in order to facilitate meaningful exercise of that right to give an impact statement, and it was ordered. And the defendant had to show up at sentencing. The victim was able to give their impact statement, and the defendant heard the defendant heard the impact of their actions, even though that wasn't something that they particularly wanted to do in the first place.
So in summary, we just want you to walk away with these final thoughts in your head. Build relationships, right? If you're a victims' rights attorney, you want to develop rapport with prosecutors, with defense counsel, with court clerks, right? You want them to know who you are. So when you go to file or when you have an issue, they're receptive and they understand your role. Think big, like we were talking about. I mean, some of these motions, some of the things you ask for, they're not common. They're not things you normally see, but that doesn't mean you shouldn't ask for them if your client needs or wants them. Be proactive, be thinking ahead, right? These rights, as I said, are ephemeral. You could lose them if you don't act. Be thinking what you need and asking for it ahead of time before it's too late. And think outside the box, right? Be creative. These motions don't have titles. You can title them however you want. I mean, we have come up with some of the craziest titles. We've thought it was just really funny to come up, be inventive, like motion for, and then just ask for whatever it is you're asking for. And it can be really seem kind of crazy and out there, but that's what you need to do to get what you need for your client based on their rights. So taking, if you leave here, those should be what you really leave here with, that you're ready to, victims can come into court, they have standing, and you're going to think big, be proactive, and you're going to think outside the box. And you've got this. Don't worry. You're not going it alone. I know that we've put a lot on you, and I know there's been lots of comments about attorneys in the box, in the chat box, like we need attorneys, we need attorneys. Well, you're not alone because NCVLI has resources. And Becca mentioned a few of those in the sense of we have a brief bank in NAVRA, and you can find it at navra.org, navra.org, and you can search our database, and it comes up with a bunch of, we have sample templates. We have a lot of great stuff. That's for paid membership, but we also have other resources that they're in trainings, etc. And then we have a TA request form, and that's at ncvli.org. You go there and you find it, and you can request assistance. So if you're like, my client needs this, I don't know how to do it. I don't know how to file this motion. I don't know if I can file this motion. I don't know if Pennsylvania allows for redo of sentencing. You can fill that request out and send it to us, and given funding and our ability, we will do our best to answer for you. This is what we live for. This is what we enjoy doing, assisting the attorneys on the ground representing victims. We love sitting, behind our desk and doing all this research and coming up with this so that you can go into court armed and ready to assert and seek enforcement of victims' rights. And with that, with 2 minutes left, thank you. Thank you for showing up. Thank you for staying for 2.5 hours. It's a long time. And thank you for the great participation and questions. And if you have any other questions, you can reach us at ncvli.org. We are more than happy to answer other questions. And we really appreciate being able to come here and talk to you about victims' rights in Pennsylvania. Becca?
Yeah, and we hope to see some of you tomorrow, where we're going to a little bit more detail about some of those appellate actions that can follow along. We focused mostly on trial court proceedings today, and tomorrow we'll continue the process.
All right. Thank you so much.